Welcome to this YouTube channel of K-Leaders. I'm Frances Chan. In this episode, I would like to talk to you about Employment Ordinance. There are several legislations in Hong Kong governing employment. In the screen, you can see a list of the key labor legislation. Among the list, Employment Ordinance is the most important piece of information that every employer and employee have to comply with. So who are to be covered and why so important to be covered? Employment Ordinance applies to really all Hong Kong employees. It is a comprehensive piece of legislation that sets out the statutory framework for the rights and liabilities of the parties in an employment relationship. It provides the minimum statutory protection for employees. This means that even the employment contract does not specify any of these basic requirements. It will be an implied term to the employment that the basic law requirement still applies. So why so important to be covered under the Employment Ordinance? It's because if it's so covered, the employee will be entitled to basic protection under the Employment Ordinance, such as payment of wages, restrictions on wage deductions, and granting of statutory holidays. Employees who have worked continuously for the same employer are entitled to further benefits such as pay rest day, pay sick leave, and redundancy payment, etc. Those employees who have worked continuously for the same employer for 4 weeks or more with at least 18 hours in each week is regarded as being employed under a continuous contract. So even the staff is termed as a part-time staff, and if his or her working hours or days are within the set 4 weeks or more, and with at least 18 hours worked in each week, then the contract that the part-time staff is working is termed as a continuous contract under the Employment Ordinance. In the absence of any express agreement to the contrary, it is deemed that every contract is continuous. In any dispute, the burden of proof is on the employer to prove that the employment is not continuous. An employee who is continuously employed may bring a claim for unreasonable termination or variation of employment contract if that termination or variation was conducted by the employer without a valid reason. In case of any transfer of business or undertaking, if the new buyer is interested to offer to the existing employee the same terms and conditions of employment, then there can be deemed to be no break of continuity of the employment contract. However, if the new employer offers less favorable terms to the employees, then the employee can refuse to accept those terms, and the employees can also entitled to severance payment if they are dismissed by the seller as their existing employer. In case the transfer is within group companies, then under the Employment Ordinance, the continuity of employment will not be affected. Under continuous employment and with length of services, employees will be entitled to pay annual leave, pay sick leave, and redundancy payment, etc. And with continuous employment, they will also be entitled to lodge claim against the employer if there are any unfair dismissal or variation of employment contract. Employment issues sometimes involve very technical details. In case of conflict or disputes, you may consider to engage a labor lawyer to assist you on handling those matters. In the next episode, I would like to share with you on how to apply for a work visa. So please stay with us and see you next time. Thank you. Bye-bye. Thank you for watching this video. If you like it, please give us a like and subscribe and share with your friends. Look forward to your continued support. See you next time. Bye-bye.